Hello everyone and welcome to today's webinar, Redundancies During and After Furlough. My name is Emma Capper. I'm an employment partner in Fieldfisher's Employment, Pensions, Immigration and Compliance team, which is also known as EPIC. I'm joined today by my colleague Rory Johnson, who is a solicitor who's also in the employment team. This session is one of a series of interactive webinars hosted by Fieldfisher's EPIC team. We will be hosting a 30-minute session every Tuesday at the same time, covering significant legal developments and hot topics, and offering some practical advice for businesses and organisations in what seems at the moment to be an ever-changing landscape for employers. So in today's session, we're going to have a look at what is the definition of redundancy, how do you follow a fair redundancy procedure, that's both individual and collective, and we'll look at some of the specific challenges and questions that we're being asked about at the moment about redundancies given lockdown and the existence of the coronavirus job retention scheme, or the furlough scheme as it's also known. Now, just as a reminder, the scheme has been extended, so it will run in its current form until the end of July, and then from August to October it's going to exist in a modified form, and we understand at the moment that there will be some sharing of the employment costs between employers and the government. So employers' responses to lockdown have taken different forms. Many companies have been able to send their employees home and have them continue to work remotely. Businesses have been designated, some businesses have been designated as essential and have continued to operate in the workplace, albeit with some protections in place. But other companies have taken advantage of the furlough scheme as a temporary measure to take some of that financial pressure off while their workplaces are closed. Now, as we all know, lockdown measures are starting to be eased, and employers are planning on how to return to workplaces and how to bring employees back from furlough leave. So it's against that backdrop that we're going to look today at how to plan if you're anticipating that your business is not going to see an immediate bounce back to pre-lockdown levels, and you instead need to make some structural changes to your workforce either during or after furlough. So Rory and I are going to take you through some of the key points that you need to be aware of when you're planning redundancies, and then we'll have 5 to 10 minutes for questions at the end. If you have questions, then there is a question box in your control panel on the right-hand side of the screen. We'll try to get through as many as we possibly can before we finish at 1:30 p.m. If we don't get to answer all your questions, then we will ask your usual Fieldfisher contact to follow up with you individually. All our sessions are recorded and they're available on the Fieldfisher website and the YouTube channel afterwards. So if we could have the next slide, please, and we'll get over to Rory to get started.
Thank you for the introduction, Emma, and thank you to everyone in the audience for joining today. So as you may know, to dismiss an employee fairly, an employer will need to have a fair reason to dismiss the employee. They will also need to follow a fair process when carrying out that dismissal. It's therefore important to ensure the criteria for redundancy is met before embarking on any sort of dismissal process. I will start my segment by looking at the definition of redundancy and the type of situation it might apply in. Now, the definition. Firstly, an employee who has completed a qualifying period of service, i.e. has worked for their employer for 2 continuous years or more, has the right not to be unfairly dismissed. The Employment Rights Act of 1996 sets out 5 potentially fair reasons for dismissal, and one of those is redundancy. Now, the statutory definition of redundancy broadly sets out 3 sets of circumstances in which an employee's dismissal can be stated to be by reason of redundancy. These are a business closure, so this is typically the closure of the business altogether, a workplace closure, so the closure of one of several sites of the business or a relocation to a new site, or the employer might have diminished requirements for employees to do work of a particular kind. Now, typically, this will be where there is either less work of a particular kind and therefore fewer employees are required to do it, or there is the same amount of work, but fewer employees are needed to do it due to advances in, say, efficiency. Now, assuming that one of these circumstances applies, the employer is likely to have a fair reason for dismissal by way of redundancy. It seems increasingly likely that the economic impact of COVID-19 will be significant and run well into 2021 and unfortunately even beyond. It's likely, therefore, we'll see more employers closing businesses, workplaces, or simply having diminished requirements for work. Identifying a fair reason for dismissal is not the end of the story, though. Next slide, please. The next step is looking at a fair process. Now, a dismissal for a fair reason can still be an unfair dismissal if the employer does not follow a fair dismissal process. Now, a fair dismissal process will typically involve clearly communicating the business reason for the redundancy to employees. So, before you begin any process, you'll need to ensure you've created a well thought out and researched business reason, as this will be referred to repeatedly and consistently throughout the process. You may wish to start the redundancy process by way of a town hall style announcement, explaining to the employees your business reason and why cost cutting and potential redundancies need to be explored. Employers will therefore have to think carefully about how announcements to the workforce are made. Although there's been a slight easing of restrictions recently, the headline message is currently, and is still going to be for some time, that we should all socially distance where possible. And if you are able to work from home, you should do so. In almost all cases, then, it's likely to be inappropriate for an employer to gather their workforces together for the purposes of simply making an announcement. Now, a solution might be to conduct town hall style meetings through video conferencing software, whilst perhaps sharing a presentation of your business case shared to their screens directly. The next step you might be looking at is the pooling of employees. Now, you should be using appropriate pools of employees from which to select those to be made redundant. For example, if one role is being eliminated from the organisation and only one person currently performs that role, it is likely this employee will be in a pool of one, i.e. by themselves. If you have the reduced need of a service you provide, and therefore you need to reduce the head count of employees but still retain that service, your pool would likely be all those employees who currently provide that service. The exact nature of this pool is going to depend on the facts of the situation and really will need to be considered carefully. You'll be then looking at selection criteria. So once you have your pool of employees in place, you will need to use objective selection criteria in respect of those employees to select between them for redundancy. Suitable criteria to select between them may be the employee's recent performance, their skill set, feedback from relevant stakeholders, etc. So things like that. It's important that employers have documentation to back up this scoring as much as possible. For example, an employee's score for their recent performance could be based on recent appraisal documentation. Selection criteria will of course not need to be used in all situations. For example, the employee in the pool of one I referred to earlier will not need to be subjected to selection criteria, as simply there won't be any other employees to select against. And finally on this slide, consultation. So you will need to consult with the individual employees at risk of redundancy, i.e. those in the pool we discussed earlier. Consultation would typically take place over the course of 2 or 3 consultation meetings with the employee. The substance of these consultation meetings should be around the company's business case for the redundancies, why the particular employees are at risk, why this particular pool of employees has been chosen, how the selection criteria have been created, and if there are any suggestions from the employee to avoid redundancy, or if there's any suitable alternative employment that may exist within the employer, or if the business has associated group companies within those group companies too. Now, you'd need to be careful not to make any assumptions as to whether an employee would be interested in applying for a particular vacancy. If the vacancy is available and suitable, you should always allow the employees in question to apply for it. At the conclusion of the consultation process, the decision maker will go away, consider everything discussed and raised during the consultation process and reach a decision. If the employee is to be made redundant, they should be informed of this in writing and given the opportunity to appeal the decision. Aspects of that consultation process I've just given a bit of background about there will clearly be impacted by the current lockdown and COVID-19. If an employer has employees on furlough leave, they will need to consider how best to contact them to involve them in this process. An employer will likely have specified the medium of communication that will be used to keep the employee informed of updates in the letter or communication which confirmed they're being placed on furlough leave. Now, if that wasn't the case, the employer will have to consider how they have contacted employees historically. Employees will not be regularly checking their work emails during this time, and so employers may have to consider other avenues of getting in touch, such as correspondence perhaps through the employee's personal email addresses or writing to them at their home address. In terms of individual consultation meetings, employers will likely be using video conferencing software to host these meetings. An employer will typically allow an employee to be accompanied to a consultation meeting by a trade union official or a colleague. The employer will also want a note taker present at the meeting to keep record of the conversations that are had. This means that any employer may need to utilize software allowing 4 or even more people on any one video call. The employer will also need to bear in mind the resources available to their employees. Whilst video conferencing is more and more popular, as more of the population has access to smartphones and laptops, some still may not. The employer will need to discuss with the employee the best medium to conduct the meetings. It may be that a traditional conference call will suffice where there is not access, for whatever reason, to video conferencing software. Now, in respect of collective consultations, as Emma will go on to discuss shortly, there are in fact further considerations. Now, if your organisation does not recognise a trade union and you do not already have in place a standing body of elected or appointed representatives, you'll need to organise the election of employee representatives. You'll need to consider how many representatives will be appropriate to cover your workforce, arrange a system by which the representatives can be nominated, and also arrange for a secret voting system to determine who will be appointed from the nominees. This will, of course, all have to be conducted remotely. Employers will typically provide the employee representatives with training as well as to their role and function, and this will also need to happen remotely. Now, where collective consultation is required, it must be run alongside the fair individual process I described earlier. Failing to do so where required can have serious financial consequences for employers. I will now hand over to Emma to tell us more.
Okay, thanks, Rory. So now we're going to have a look at collective redundancy procedures in a bit more detail. So when does an employer have to collectively consult about redundancies? Well, the trigger is where an employer is proposing to dismiss 20 or more employees at one establishment in a 90-day period. Now, the issue of an establishment and what that actually means can be a difficult area. There's been lots of case law on this, and the latest case was the Woolworths case. Some of you might remember when Woolworths went into administration. And ultimately, it was decided that establishment should be looked at in the ordinary way. So where would the employee's local workplace be? That's the starting point. But it's not always that straightforward, and each situation has to be looked at carefully. And it's certainly a point that we have to advise on regularly. So you should be taking advice on that if you're not sure. Different minimum periods of consultation apply. So that depends on the number of redundancies that are proposed within that 90-day window. If you have 20 to 99 redundancies proposed in the 90-day time period, then the consultation period must be at least 30 days long. Where there are 100 or more proposed redundancies, then the consultation period must be at least 45 days long. But there's an overriding obligation for consultation to take place in good time in order to enable effective and good quality consultation. The other important point to remember here is that the 90-day window is a rolling time period, and that can be a particular problem if you're looking at phased or staggered redundancies, for example. So that's one to keep an eye on. And you really should be thinking about these consultation periods in the framework of the remaining furlough period if you're looking at employees who are on furlough. So in an ideal world, you would have time to consult for the required 30 or 45-day period and then issue notice of termination of employment so that the notice period can run during the remainder of the furlough leave rather than spanning any period after the end of furlough where the employees may have come back to work. So who do you consult with? Well, as Rory's indicated, there's a duty to inform appropriate representatives. And there are three potential categories of those. So firstly, representatives of a recognised trade union. Secondly, they might be directly elected representatives who have been elected specifically for consulting about the redundancy proposals. Or lastly, there might be a standing body of elected or appointed representatives who haven't been elected specifically for this redundancy consultation, but who already exist, and it might be appropriate for you to consult with. Now, if there's no recognised trade union and employee representatives are going to have to be elected, there is a statutory process that needs to be followed for that. And as Rory's indicated, you need to consider how that can be done remotely. So we're seeing clients using an online platform to enable employees to vote. You also need to factor this into the timetable for the redundancy process. So elections might take at least a week, 10 days, and you need to build that on at the start of the time period. Employers will also give reps some training once they're in post and before the process starts so that they understand the role that they have to play. So that would add a further element to the time period. So really you're looking at adding on perhaps a couple of weeks minimum to that 30 or 45-day consultation period. And you should be thinking that things might take a little bit longer to set up and arrange than they otherwise would have done if we weren't in lockdown. Now, in terms of employees who are on furlough, remember that employees shouldn't really be doing any work whilst they're furloughed. There's a requirement that they shouldn't provide services to their employer or generate revenue for the employer. So how does fulfilling the responsibility of an employee rep fit into that? Well, we know from government guidance that's confirmed that employees who are on furlough can carry out their duties as employee representatives for the purpose of redundancy, and that won't break the furlough requirement that employees shouldn't be working whilst on furlough. So that means employers should not be excluding furloughed employees from standing for election. Now, what do you consult about? Well, consultation must be with a view to reaching agreement with the appropriate representatives on ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of the dismissals. And it's really important to demonstrate as an employer that you've explained the proposals to the reps, you've listened to their feedback, you've gone away, considered it, and then responded to them as to whether proposals might have been accepted or rejected. Now, there are some technical but necessary formalities for employers at the start of the process. Employers are under an obligation to notify the Secretary of State of the proposed redundancies by submitting a form HR1. This is absolutely critical, and failure to do this is a criminal offence by the directors of the company. So that really is one not to be forgotten. There's also a requirement to give certain information in writing to the employee representatives, and you might have heard of that being described as Section 188 information derived from the statute where the list of information sits. And it's giving this information that really starts the clock running on the 30 or 45-day minimum period. Now, the consequences of getting it wrong are significant, as Rory has indicated. So I've already touched on the fact that it's a failure to submit an HR1 form is a criminal offence. Employee representatives, though, can also bring claims for failure to inform and consult, and tribunals can make protective awards of 90 days gross pay per employee. So that really adds up. And it's important to note that an employment tribunal will start at that maximum 90 days per employee and then only reduce it if there are reasons why the award should be reduced, so mitigating factors. And that's in addition to the usual unfair dismissal claims arising from the dismissals, or indeed any claims, for example, that dismissals have been motivated by discriminatory reasons. And don't forget adverse publicity of claims or the press being tipped off during the process of consultation itself. Now, we've had lots of questions from clients, and I can see some coming in around special circumstances and a defence that exists that some of you might have heard of. So an employer can argue that there have been special circumstances, which means it's not reasonably practicable for the employer to comply with the requirement to consult in good time and for the minimum periods, or about the information we've just talked about. And the question really has been, does this pandemic count as special circumstances so employers don't have to collectively consult? Well, the point to remember here is it's a really high test. This often arises in insolvency cases and is argued there, and often argued unsuccessfully, even in those serious circumstances. And of course here, the furlough scheme exists, and so in theory that could be used to keep employees employed for the relevant period of consultation. And it's also worth noting that in relation to that defence, employers should still be taking all steps to comply as are reasonably practicable. So, as you can see, planning is absolutely critical, both in terms of setting out your business case for redundancies and the timeline to be followed. And if you're unsure of the process, if you're starting it in your business, then please do get in touch with your usual Field Fisher contact. Now, it looks like we've had some questions in. Rory, what have our audience been asking us about? Shall we have a look at the questions?
Yes, definitely. Thank you for that, Emma. So, like I say, lots of great questions from the audience off the back of that. To those of you who haven't managed to get your questions in yet, I think Emma said at the start of the talk, but there's a questions box on the right-hand side, so please do feel free to pop the questions in there. One that I've seen a lot sort of worded in slightly different ways, Emma, in the question box, but the gist is broadly, will my company be criticised for not using the furlough scheme and just moving to redundancies?
Okay, this is a really good question, and again, one that we're being asked quite regularly. The starting point for this is that there is an obligation when you're conducting a redundancy process to consider what alternatives there might be to redundancy. And of course, one alternative might be to use the furlough scheme, but there's no absolute obligation to use the scheme. And this really needs to be considered on a case by case basis. So you're really looking at, is there a reason why within your business the furlough scheme wouldn't work for you? So do you need to put in place restructuring measures now to stand a chance of recovering from the crisis? Have you got to do that now so that you can get back on track as quickly as possible? And I suppose the important point that sometimes gets forgotten here is that it might not be the case that furlough is cost neutral. So, for example, by the time you've added on enhanced pension contributions that you would be liable for as the employer, you might not actually be able to withstand the cost of running on the furlough scheme. And particularly given that it is only going to last now until the end of July, and then from August to October, there'll be this possible sharing basis between employers and the government. So that will make it more expensive to use as well. Have we got any other questions coming in, Rory?
Yes, we have. Thank you for that, Emma. I've got one here that says, can we use the furlough grant to pay for termination payments?
Right, okay. So when you are terminating employees for reason of redundancy, you need to pay statutory redundancy payment and notice monies, whether you ask them to sort of work out notice or you pay in lieu. So let's have a look at those in turn. So the grant won't cover a statutory redundancy payment, nor will it cover any enhanced redundancy payments. We believe that it's possible that an employee can serve out their notice period during furlough, and that you could therefore use the grant to pay notice monies. There's a really strange sort of historic piece of legislation here that you need to be aware of, that usually comes into play when somebody's off sick and they've exhausted their sick pay and they're on nil pay, and there's a question over whether they have to be paid full pay or nil pay for the notice period. As I say, it's a strange provision, but it applies here in the furlough period because the employees are on reduced levels of pay. And the rule is this: so if someone is entitled to only statutory notice, and that's the 1 week per year of service up to a maximum of 12 weeks, then their notice period should be paid at their normal rate of pay, i.e. not the reduced furlough rate. So employers would have to top up that furlough rate to normal pay levels. If an employee, on the other hand, is entitled to at least a week more than statutory notice, because their contract specifies something more than that, that rule doesn't apply, and you might be able to use the reduced furlough rate of pay and not have to top up at all. We'd want to have a look at what you've said in your furlough agreements or letters with your employees and how the reduced level of pay has been presented to them. But as a starting point, you may be able to pay notice monies on that reduced rate. And then if you decide to make a pile-on payment instead, which you may do, then it would seem that that's going to be on normal full rate of pay because employment has ended and you can't take advantage of the furlough scheme for an employee where their employment has ceased. So hopefully that answers that one.
Yes, that's great. Now, I mean, I should say we've had lots of fantastic questions. I think one of the perils of having a short webinar slot is that I don't think we'll be able to get to any more of them. But I think, as Emma said at the start, what we will do is we will answer your queries, and a response will come through your usual field official representative. I think I'm right in saying that, am I, Emma?
Yes, absolutely. Yeah, that's great. We will have a look at the questions and we will pick up with you individually if we haven't managed to get to you. So apologies for that. So thanks very much, everyone, for joining us today. We hope you found the session useful. Just a reminder, all our sessions are recorded and can be found on our website and YouTube channel. If you want to discuss the topic further, please do reach out to your usual contact in the employment team, and we will be delighted to talk to you further on this. And just as a reminder, we hope you can join us next week for a topic which will be just as interesting, I'm sure. It's the coronavirus job retention scheme and HMRC enforcement. Thanks very much, everyone, and keep safe.